Hi, I'm Adrienne Oliver, an attorney at Garlick & Bousfield Incorporated, practicing family law. Following on from our previous episode, let's now chat about divorce. It is incredibly helpful to get advice on what the divorce process might look like before proceeding. This is in order to understand what a person may or may not be entitled to, what the negotiation process is like, how long these proceedings are expected to take, and what the cost implications are. There is a common misconception that approaching an attorney for assistance with a divorce means that it will go to trial. This is certainly not the case. An attorney's role is to resolve a matter as quickly and as fairly as possible. Divorces can be quite simple, as parties have the opportunity to proceed with mediation before litigation. Alternatively, the parties may enter into a settlement agreement with the assistance of their attorneys and have the matter finalized on an unopposed basis. This is usually the most appropriate approach, especially if there are children involved, and it can take between 2 to 4 months at most. On the converse, divorce proceedings can also become quite grueling. This is when the parties cannot reach agreement, there is a lack of cooperation between the parties, or a lack of willingness to cooperate with one another. A divorce commences with the issuing of a summons, which is served on the other spouse, who is then referred to as the defendant, and within 10 days of service of the summons, the defendant has an opportunity to file a notice of intention to defend. After delivery of the notice of intention to defend, the defendant may respond to the allegations made in the plaintiff's particulars of claim by submitting a plea and usually a counterclaim. The plaintiff may thereafter file a plea to the defendant's counterclaim. The pleas filed by the plaintiff and the defendant contain admissions and denials of the various allegations made by each of them. Once all pleadings are filed, trial preparation may begin. This route, while available to all parties, is long and at times difficult. An opposed divorce could go on for years, and it may be delayed by issues of a financial nature, interim care and contact arrangements in respect of minor children, or domestic violence issues. In circumstances where one spouse has been financially dependent and requires continued support from their spouse during the divorce process, for themselves or for the children, or if they cannot cope with the costs of litigation, such party can approach the court at any time before the hearing of the trial for interim maintenance, interim care and contact arrangements, and a contribution towards their legal costs. This can be done in terms of a Rule 43 application in the High Court or Rule 58 in the Magistrates Court. A Rule 43 or Rule 58 order provides interim release pending the outcome of a trial and is incredibly helpful when there is such a significant wait to get to trial. It is possible for a party to institute divorce proceedings without the assistance of an attorney, and a divorce can be finalized quite simply and quickly through settlement between the parties. Be honest and open. It is better for everyone, especially if there are children involved. For all inquiries, please feel free to contact me on 083 637 1845. Thank you for watching.